Well, welcome to Direct U.S. Immigration's channel, where you get direct access to our most up-to-date immigration and global mobility space. I'm an immigration attorney with almost a decade's worth of experience, and today we're going to talk about U.S. citizen petitioners on disability applying for a U.S. fiancé visa for their foreign fiancé. Stay tuned. Thanks for tuning in. My name is Maitreya Brown, and I'm a U.S. immigration attorney based in Washington, D.C. I'm also the principal attorney at Direct U.S. Immigration, where we work with clients in all 50 states and around the world. The fiancé visa, also known as the K-1 visa, allows the U.S. citizen to bring their foreign fiancé to the U.S. to get married. The process involves filing a petition with USCIS through Form I-129F, followed by additional steps at the U.S. Embassy or consulate in the fiancé's home country. Before the U.S. citizen can file Form I-129F, the U.S. citizen and foreign fiancé must have met in person at least once in the preceding 2 years before filing the petition. However, exceptions do apply to this rule if meeting in person would conflict with religious or cultural traditions, or if it would result in severe hardship to the U.S. citizen. If this is applicable, the petitioner must seek a waiver to the 2-year rule. To substantiate the request, the petitioner must include evidence of the religious or cultural traditions or severe hardship. If the petitioner has a disability or autoimmune disease that affects mobility, sufficient evidence may include the following: medical documentation. So obtain thorough medical documentation that clearly outlines the nature of your disability. This may include reports, diagnosis, treatment plans, and statements from medical professionals who have evaluated your condition. Letter of a medical professional. Request a letter from a medical professional, such as a doctor or a specialist, that explicitly outlines the nature and extent of your disability. This letter should also specify any limitations or accommodations that may be necessary. An explanation in the cover letter. Include a cover letter with your visa application that explains your disability and how it might impact the application process. Clearly state any specific accommodations or considerations you are requesting. In addition to this, you must also show evidence of a true relationship. Documents that prove a bona fide relationship may include, but of course is not limited to, photographs, letters, call logs, or any other evidence that showcases a relationship between the petitioner, so you, the U.S. citizen, and the fiancé. Once you have compiled all supporting documentation, Form I-129F must be filed with the intent to establish the relationship and eligibility for the fiancé visa. After Form I-129F is approved, USCIS will send the approval notice to NVC and the U.S. Embassy or consulate closest to your foreign fiancé. During this time, it is important to prepare an affidavit of support through Form I-134, demonstrating the ability to support the foreign fiancé financially. If the petitioner's disability affects their ability to work or meet the income requirements, alternative forms of financial support, such as assets or a joint sponsor, may be considered. Additionally, the foreign fiancé must undergo a medical examination to ensure they do not have a communicable disease of public health significance. Disabilities or health conditions are generally not grounds for a visa denial. However, any accommodations needed during the medical examination should be communicated in advance. Now let's talk about the interview process. If the foreign fiancé has mobility issues that may affect the interview process at the U.S. Embassy or consulate, it's important to inform the relevant authorities in advance. They may be able to make accommodations or provide guidance on specific requirements. Overall, it is important to communicate. If the petitioner or the foreign fiancé's disability affects their ability to complete forms or attend interviews, it is advisable to communicate directly with the applicable immigration agency. The immigration agency will provide guidance or make accommodations where possible. Clear and proactive communication is crucial to address any specific needs. Consulting with an immigration attorney experienced in handling cases involving disabilities is highly recommended. An attorney can provide personalized advice, review documentation, and navigate any potential challenges to ensure that the application process is as smooth as possible. Navigating the fiancé visa process with a disability requires careful planning, clear communication, and possibly some adjustments to accommodate specific needs. Seeking professional advice and staying proactive throughout the process can contribute to a successful visa application. Last but not least, be sure to check out the caption below this video. We've got questionnaires for different types of visas so that we can help you determine which visa is most appropriate for you. And if you're traveling soon, we also have a list of some of my travel favorites. So I hope you found this video helpful. Subscribe if this content or information helps you in any way. Comment below if you want me to talk about something in specific, and share this resource widely because you never know who needs answers to these questions. Additionally, if you have any specific questions as they pertain to your unique circumstances, please schedule a consultation with us, also at the link below, and I'll see you in the next video.